My first year out of law school, I spent the year doing community-based work in housing law and employment law. On the housing side, mostly working with tenants associations and tenants fighting gentrification in collaboration with City Life Vida Urbana and other grassroots organizations to try and fight displacement in Greater Boston. And on the employment side, mostly taking on wage and hour cases in the restaurant industry and the construction industry. And I take direction from the community in terms of the kinds of cases that I take and the kinds of legal strategies I use to develop those cases. And I think on another level, it's an ethic in terms of the way that you practice. I try to think about lawyering not just as giving good advice, but also building capacity for self-advocacy and for sort of tailoring both the advice that I give and the legal strategies that I use toward building that in my clients, towards making my clients the best equipped self-advocates they can be as well. Definitely leaning on organizers and leaning on community groups to take the lead on that front and to help me and to build capacity where they can. I think it's client empowerment, and it's leaning a lot on the community and especially grassroots groups that represent the community.
Since August of 2015, this landlord, he's been going downstairs in the basement, turning off the lights on me. I've been going back and forth to the city, complaining about the lights being off, the heat's been off in the wintertime. I had to sleep with hat, jacket, and everything. 3 or 4 comforters on in the wintertime. He turned my lights off and he turned hot water off.
Every time we ask him to fix something, he don't want to fix it.
The landlord was cross-metering, so the tenants didn't have heat and hot water or appropriate heat and hot water. The conditions of the building itself were in disrepair. He was unavailable, the landlord. He would not respond to any complaints.
Some of the units had been cut up in pieces without proper governmental approval. They had extension cords running from one apartment to another to supply power. The city had been involved in terms of a catalog of violations.
It came out, because the tenants didn't even realize this, that the landlord had been in bankruptcy for about 2.5 years. And so when that was out there, that was when the plans sort of started coming together. And really it was Lawrence Song and Matt Nickel who did the initial sort of legal strategizing and sort of thinking about how this could happen. They reached out to Bob Sable, who does bankruptcy, who knows bankruptcy, who made the connection with Pillsbury and Jones Day and Goulston Stores to make sure that we had a team who would be equipped to potentially pursue these buildings in bankruptcy.
I want to find out what more are my rights on this type of situation I was in. Because bankruptcy is like you don't know who's going to take over, and I was getting a little scared. I was upset, I was very angry, I was confused, and because I didn't know what was going to happen, I didn't know what to do.
Steve Meacham contacted me and said, there's this building, we don't know much about it, but Greater Boston Legal Services is already representing 3 tenants in this building, and we think the landlord is in a declared bankruptcy, and we think there's something that's worth organizing there. So I went there, and I think from that time on, I was in these buildings at least once a week for 5 months.
We got involved and we started to craft a strategy. And the first part of the strategy was not to let this debtor do what he wanted to do, which seemed at its core to wipe away claims completely by tenants for inhabitable conditions, for violations of zoning laws, for improperly constructed apartments. The strategy we constructed worked phenomenally well because ultimately this debtor got dispossessed of control of his own assets, and we got a trustee appointed.
The plan was put on hold. A Chapter 11 trustee was appointed, again, a neutral third party, not involved in the case, somebody who's subject to court oversight, who's supposed to come in and try to figure out what was going on there. And that really gave us an opportunity to work with the trustee, work with, again, someone who is supposed to do equity.
We had to show that we had literally millions of dollars of claims against the landlord. And Joey was one of the key people that put together the legal theories that that he owed us, owed our clients all of this money.
With the assistance of your fellow, Joey Michalakes, and the GBLS staff, the tenants were each interviewed and their claims assessed and considered and aggregated so that there was a huge bundle of claims that were worth about $3 million.
These were people in really dire straits who were willing to spend a lot of time being interviewed and get their affidavits together. They were willing to put their name on a document explaining what had been done to them and why it was wrong. They were really willing to take a stand.
The tenants were willing to waive their legal claims against the landlord as a way to add value to a bid from a nonprofit.
These people said, we'll invest in our future with our claims.
Mi nombre es Ivette, soy una de las organizadoras de la comunidad de la organización que quiere comprar el edificio para que las rentas se queden para la comunidad.
The court could take into account the claims of our clients as part of the bid. And so I don't remember the numbers, but let's say that we were willing to bid $2 million, but we were going to give up, our clients were going to give up $3 million worth of claims. So the question is, could the judge treat this as a $2 million bid or as a $5 million bid? And Joan Pillsbury argued brilliantly that it should be a $5 million bid.
The nice thing in the bankruptcy context is when you're talking about return to creditors, which is again that economic focus, you can improve the return to all creditors either by getting more money or by reducing the claims. So if you come into bankruptcy and you say, I have these claims with this dollar amount, and in connection with this path forward, I'm going to release my claims, well, you've just improved the return to creditors. And that has real value to it.
So that's what we're fighting for, a nonprofit to get these apartments and for them to have affordable rent for a period of 50 years.
Yeah, exactly. We had rallies in front of Waldeck. Made me feel more confident about myself. I don't want to leave where I'm at. I like it here. I like it in Fields Corner. There's a lot of generations within this city of mine, you know, and we shouldn't be forced out or displaced.
I don't see why we should get penalized when building owners fail. Why tenants need to get penalized. And just to let you know, I came from the hospital to this apartment, so I've been here for 41 years. That's my age, and I don't feel that I should go anywhere.
That's right.
I remember the courtroom being full of tenants, and they were all wearing these lime green shirts, and I'm just really hoping for the best for them.
It turns out at the bankruptcy hearing, there was three contenders.
And Codman was was the only developer who said, we want to maintain this property as low income and affordable, and we want to keep all of the tenants where they are currently. We just want to make the property habitable, essentially.
I made this point of the argument that, Your Honor, there are some things that are more important than money. And there was a sudden commotion and a cheer went up from the back of the courtroom, and I realized that there were numerous of the tenants in the back of the courtroom wearing bright yellow t-shirts with slogans on them, and I've actually never had an audience cheer for me before in court. It was a really special moment.
I have cheered for him after court.
That's right. But again, that level of, when you talk about why one does pro bono, a corporation doesn't give you a hug, right? These were people whose lives were being fundamentally changed, and so much for courtroom decorum. They let everybody know that they were in support of the argument.
Together with Coulson and Storrs, we were able to convince the judge that the dollars from Codman plus the waivers of these claims exceeded in value the cash component of another bidder. When
it was awarded to Codman, the entire room erupted in cheers, and it literally brought chills to I had chills and tears were in my eyes. I felt like I was a part of something that was really big.
Folks were empowered by this success. And so not only are their circumstances, hopefully living circumstances, improved, but I think their community strength is improved because they understand what they can do as a group when they constructively take on powers that are otherwise market forces that seem very difficult to tame, and in this case they did.
I'm impressed with them. They come and have a guy come and clean it every day.
These buildings now are secure for another 50 years for affordable housing.
Public interest lawyers are important to people like me or anybody who has low income, who I'm on disability. I couldn't afford lawyers are expensive, and I couldn't afford a lawyer. And evidently they work with the tenants of these the buildings that are owned by Oru-Lawrence to make sure they get the proper representation. And they did it for free, and they were good. I was impressed. They really cared. Their heart was into it.
We also couldn't have done this without our experts who gave color and numbers to these claims. Retired Superior Court Judge King, who presided over numerous landlord-tenant disputes, was able to give his opinion to the bankruptcy court judge about the validity of these claims. Ethan Maskew was able to describe for the judge the egregious conditions. He's a sanitation expert.
When you see the client caring and having so much of themselves put into the case, you feel sort of inspired yourself to put that much in as well, to sort of be there with them. And I think Joey and the team at GBLS was probably the best embodiment of that, and that they were the ones really on the front lines, directly in contact with the tenants, sort of helping them as problems arose.
Andrew and I were able to contribute a lot of firm resources, but this wouldn't have happened without the support of Greater Boston Legal Services, without the support of the DAG Fund, and its and Joey's role in particular. People who are out there able to do well, to do good for society, and to get the support of society that they deserve in order to make a difference that benefits all of us.
I don't think it's any exaggeration to say that if Joey hadn't been there, if Joey hadn't had that funding, we might have had to just take a pass on this and say it's important, but we just don't have the capacity.
It's so wonderful that there's money available, that there's resources out there for people to do this kind of work. And in a time when legal services funding as a whole is under threat, both the explicit threat of potential budget cuts at the federal level, and also just state budgets, constantly being as strapped and as tight as they are. I think we need all the help that we can get. And I think having funds out there specifically to help lawyers build power in marginalized communities that have been disempowered for generations, it's extremely meaningful. It's extremely powerful. And I think any lawyer who wants to make a difference, who wants to spend their career forming relationships with communities and forming relationships with clients and community organizations that can potentially change the world, I think it's an incredible opportunity.